For listing this matter, my lord, because last it is the 13th of March, my lord. On next Thursday night, they are listing 17th.
17 not possible. We can have it on 22nd, 24th.
Already.
22nd.
Listing of a matter.
Orders 22nd.
One another matter. Item number 4, Lord.
Hmm.
Today we have some typical discussion, maybe pass on for detail.
Item 4 at the request of Mr. Council so and so. Let us then suggest for the day. Yes.
With the consent of the other side, I want to mention item number 12.
12.
May be taken after 12.
Item 12. At the request of MS so and so learned counsel appearing for the petitioner. You are appearing for whom? Petitioners. Let us stand adjourned for 2 weeks. 2 weeks.
May I please? Lordship, I beg to mention writ petitions, the writ petition number 641 of 2022 or 2020 for listing tomorrow. Lordship, the party is instructed to withdraw the matter.
Tomorrow. All right.
Yes, Lordship. I have message.
Maybe, Lordship, I like to mention item number 8, Lordship. Letter will be open for the day only.
The request of your name.
It's like
MS so and so matter stands adjourned for the day.
May I please notice? I recommend for listing 3 petition relating to the promotion matter.
Admission matters.
Yes, ma'am.
24th August.
Another one is review, ma'am. Review whether now is after I have said for you.
Review will be listed. Review will be listed by the registry. Review.
Yes.
You make a mention before the registry, they will get it listed as per the orders passed by the Honorable Chief Justice or the administrative state. Yes, yes.
Yes, Lordship. I beg to mention item number 26 of daily list, Lordship, on behalf of Planet Council NS Sakoya. As he is out of station, Lordship.
In this case, while I am appearing for private school, when they have not taken contact with us, there are some urgency, let the matter is well.
She is out of station.
Out of station, due to some enquiry commissions, you have to go to out.
When is she? Give a date, we can fix it up.
Right.
Give a date. When is she back? When is she going?
1 week, Lordship. After
1 week.
Next week.
Next week.
On 14, well,
14th.
Well,
All right, 14th.
obligation.
15th.
I beg to mention item number 48, Lordship. The respondents agreement to take instruction, Lordship, and said they could not be here on time. It is fine mentioning, Lordship.
You're mentioning on whose behalf?
Lordship, I'm for the petitioner, Lordship.
You are for the petitioner.
Yes, Lordship.
You're mentioning on behalf of the respondents.
Respondents, they could not be that.
We'll see as when it reaches. By the time the matter reaches, I'm sure they will be here.
Lordship, consent is there, Lordship. Lordship, my kindly.
You can't make a mention on behalf of the respondents. Let them come. Why you making? You want to adjourn? We can adjourn the matter at your instance.
Lordship,
Right at the request of MSS Kemprai.
Lordship.
Matter stands adjourned for 1 week.
Okay.
Item 50 of the supplementary list, my lord. It is the APSC matter, my lord, that candidate is before your lordship. My lord, we have already filed an additional affidavit. This may kindly be called on record, my lord.
Or if you give the particulars.
Yes, one more thing, my lord. We have also filed a repetition, my lord, on Saturday, my lord. That may also be called, my lord.
No, that can't be called. We'll see. You file the writ petition, it will come before the appropriate court through the registry.
Same matter, my lord, because they have filed past and speaking order, we have challenged them.
No, unlisted will not give you unlisted today. What is the urgency?
Urgency, my lord, the item number 50, my lord. During the pendency of the case, they have passed and speaking order. Against that speaking order, we have filed that the affidavit is there, we have filed it in this case. And we have filed a writ petition to set aside that speaking order, that's why there is an urgency.
To correct. That urgency can be taken up tomorrow or day after. Let both the matters be listed together.
My lord, interview is going on, it started today, man.
Ah.
And my
Let
lord,
let it be tomorrow then, let it be tomorrow. Let both the matters come up tomorrow along with the fresh writ petition.
That can be done.
Yeah, do you have a mention memo?
My lord, we will give my,
Let, is the writ petition numbered?
serial number is there. I can give the serial number.
No, serial number will not help. You have to give the number.
My lord, can it be done like this, my lord, may I hear this, item 50, my lord may hear this, if lordship is satisfied. The lordship may allow her to sit in the interview, then my lord, both the petition can be heard tomorrow.
All right.
I'll just, then my lord, as of now, we are just calling them additional. Obliged.
There is list for motion, I think one.
Yes,
Pertaining to complaint on appointment, the father of the petitioner.
yes, obtain your instructions. Get your instructions.
Lordship, otherwise with statement delayed access. That part delivery is sufficient.
No, other than that, you get the instructions in respect of this matter. Other councils. The petition pertains to filed by the petitioner. Because the petition is agreed by the fact that the case of the petitioner seeking compassionate appointment has not been considered by the competent authorities. Mr. D. Boran and Council for the respondents.
1 and 4.
1 and 4 MS. So my hearing for
5, 6.
2, 3, 5, 6. 2, 3, 5, 6 and 7. We'll obtain the required instructions and place it before the court. How much time will you require? 1 week?
1 week, 2 weeks.
2 weeks, list after 2 weeks. 21st August.
Item number 2.
Yes,
And after that, SRP has rejected. Getting that there is no vacancy. Therefore, the petitioner is not directed. To consider whether any other vacancy is there, any other department. Would have considered that.
where is that order?
Last order, man, that is. Annex of 5.
Where is your name?
For now, pretty corridor. Serial number 4.
4.
The same ground. You don't consider another department.
They say it cannot be considered because of want of vacancies.
Yes, earlier, it was rejected on the same ground.
Here, Mr. Sutia, please get your instructions whether the lack of vacancies is only in respect of the respective department or all the vacancies. Order the minutes does not reflect in detail.
Because want of vacancies, if this 5% is not for hard, then they cannot afford more than 5%.
Where?
Vacancies should be within the 5%.
5% where?
One of the either department, the department.
Then what is the meaning of clause 15?
Those 15, they will have to go for this department. And this department. will-
That was the direction of the court earlier. You have not seen the earlier order.
Oh. Yes,
Page number 23.
yes.
There was a direction.
It is not available in a particular office. They close 15. As per close 15. As per close 15, they should ask the other departments whether any vacancy or not.
Whether it was done,
Paper, I don't know.
that is why we wanted you to get the instructions.
Not to pay it to notice by law. If you meeting, I have offered.
I heard
And if you meeting by law, the parties are will not add the
you should
SFC.
notice. And who is to be added?
SFC is not made party.
Why SLC is necessary?
SFC is necessary because they have rejected it.
SLC is here already a party.
No party.
Number 2,
Number 2 is a still, oh, yes, yes, yes.
heard learned counsel for the parties. Issue notice. of
I have
motion
got to wait.
returnable 4 weeks. Since Mr. T. Sutia appears for respondent. You are appearing for respondent
I have got to wait.
2 and 3. Notices are waived, however, extra copies will be furnished. Mr. Polita and Kalita for respondent 1 and 4. Since the, we write together, since the learned councils are have represented the respondents, notices are waived, however, extra copies will be furnished. Stop. The petitioner is before this court, sealing the order dated. Sealing the minutes dated 18 January 2020 of the SLC, prepared by the case of the petitioner, along with other similarly persons were considered, but petitioner was not given appointment on the ground of lack of vacancies. Stop. The council for the petitioner submits that the subsequent minutes was pursuant to direction of this court, passed by order dated 13/3/2019 in WPC 8672 of 2018, whereby the SLC was directed to reconsider the case of the petitioner, keeping in view the para 15 of ON number so and so dated 1/6/2015. Stop. Learned counsel to the petitioner submits that the same was not done and the petition and this order was passed, rejecting the case of the petition. Around the next returnable date, the councils will obtain required instructions as to whether the SLC considered the case of the petitioner in the light of the directions passed in order dated so and so, WPC so and so. Yes, I'm told.
Item number 3,
Or steps within 1 week. Yes, dismissal. Dismissal,
Oh my. Removal.
removal.
The factual metrics of the case, cannot take receipt portions are initiated against the petitioner and accordingly, it was framed allegedly accusing against the petitioner for leading over to void beyond the sanction limit of 5 lakh from various debts, while he was serving a respondent to bank. And thereafter, my note, an inquiry was initiated for looking into the allegations on conclusion of the inquiry proceedings, my lord. The inquiry authority out of 7 allegations had 5 as true, 2 as not true, and the respondent concurred with the views of the inquiry authority. Thereafter, my lord.
What was the order passed?
My lord, thereafter, the respondent for my lord passed an order for dismissal from service, my lord. And the petitioner submitted an appeal against the dismissal order. And against that dismissal order, the appellate authority had converted the dismissal order to removal. Right? Against that removal order, my lord, the petitioner had preferred the writ petition impugning the order of removal. My lord. And this honorable court, my lord, had its order dated 3/1/23, my lord, was pleased to pass an order entered in holding that the matter be remanded back to the appellate authority for a consideration into what appropriate punishment can be meted out to the petitioner that he had availed personal loan beyond the central limit of 5 lakh without obtaining any sanction for the purpose, although availing personal loan beyond 5 lakh within the otherwise enhanced limit granted by circular. There was a circular, my lord, as in pursuant to that circular, he was eligible for overdraft facility, my lord, beyond 5 lakh. The petitioner accordingly be directed to appear before the appellate authority for further consideration as to what lesser punishment can be meted out to him in view of the conclusion arrived at that even the punishment of removal from service would be disproportionate to the charges proved against the petitioner. The bank authority also take note of the present status of the petitioner while considering as to what appropriate punishment would be suitable for the petitioner if the punishment of dismissal from service or removal from service would be unacceptable. Accordingly, the order of removal from service stands interpreted, and the respondent through the appellate authority may pass a fresh order taking note of the entire aspect. Thereafter, my lord, what happened? The matter was remanded, but in instead of reconsidering the matter in the light of the observation passed by this honorable court, my lord, they had preferred a writ appeal before the division bench, honorable division bench, my lord, and
Which was subsequently
yes, my lord,
which was withdrawn.
please to dispose the
Withdrawn.
writ appeal and the order was upheld, my lord, affirming that order. Thereafter, my lord, the matter was remanded to the appellate authority for reconsideration. After providing opportunity hearing and passing a recent order dealing with the grounds of appeal without dealing with the grounds of appeal. My lord, what happened that respondent number 6, my lord, while had reconsidered the appeal and had ordered that the observed and held intended the petitioner has committed serious lapses in discharging his duties with considerable misconduct and observed the punishment of removal from service imposed thus is commensurate with the gravity of lapses committed. There is no need to modify. My lord, they have clearly disobeyed the order passed by the honorable single bench as well as the division bench. To modify the same and respond to the fixed order accordingly.
Then you should have filed a contempt. You should have filed a contempt.
Instead of filing the contempt, my lord, we filing press.
Why?
Press the petition, my lord.
There is already a direction.
Yes, you. My lord. Yeah, my lord. My humble submission, my lord, in view of the e-circular, my lord, pertaining to personal loan scheme of the employees of the respondent act, it has been provided that the availability of personal loan to the income following the petitioner would increase 5 to 7.
What was the direction of the court, single bench earlier? Para 29,
Yes, my lord.
page 95.
Yes, my lord. Direction was.
So this direction remains, it was not interfered in appeal. Appeal was withdrawn, filed with the
Yes, ma'am.
bank.
Yes,
So
Yeah,
if,
withdrawn the
if this has not been complied with,
yes, ma'am.
you have your remedies before
My
court.
lord, as per the respondent bank, my lord, they had complied with the order. And by complying with the order, they have made certain observation, my lord.
What was the,
Their observation was, my lord, in page number 1185.
118?
Most of the submission made by the appellant in his submission are reiteration and discussion, the appellate committee observes the agenda. These are their observation. They have complied, but once again they have removed the petitioner. And because the entire petition was adjudicated on merits, after conclusion of judgment was passed, and appellate authority were directed to reconsider matter in the light of the observation made by the.
We will issue notice heard learned counsel for the petitioner. This writ petition has been filed with the petitioner challenging the order. Where is the order? Where is the order?
Order, my lord, annexure 30, my lord.
Page number.
Page number 104, my lord. And this order was 10/7/23, my lord.
Where does the order begin? Order dated 10/7/2023.
Yes.
Passed by the appellate authority of the SBI Bank. What is certain? Whereby the earlier punishment of removal from service within courts was sustained by holding that on the grounds and reasons mentioned in the order, there was no need to modify the same. Stop. Learned counsel for the petitioner submits that against the order of punishment which was earlier imposed, petitioner had approached the court by filing WPC number
This was
1564 of
15.
2015. His writ petition was disposed of by a coordinate bench by order dated 3/1/2023, whereby the order of removal from service dated 9/8/2012, which was imposed by the disciplinary authority on the petition, was interfered with. And the appellate authority was directed to pass a fresh order, taking note of the entire aspect of the matter as indicated in the order. Stop. The recent order was directed to be filed, to be passed in a period of 6 weeks from the date of receipt of the certificate copy of the order. Stop. Against this order, bank preferred a writ appeal. The writ appeal number 161 of 2023. Stop. By order dated 31/5/2023, the writ appeal was disposed of as withdrawn. And the appellate authority was directed to reconsider and dispose of the appeal by providing opportunity of hearing to the petitioner and pass reasoned orders within 6 weeks from today, without being influenced by the findings recorded in the order passed by the learned single judge. Stop. Learned counsel for the petitioner submits that in spite of the specific directions in the court by the learned single judge, by the order dated 3/1/2023 passed in WPC so and so, petitioners reiterated their earlier findings and sustained the order of removal from service. Stop. Being agreed, the present petition has been filed. Let notice be issued, returnable 4 weeks. Steps on the respondents by registered posts 80 within 1 week from today. You are already released from service.
Yes, madam. The last 30 I have.
You are no longer in service.
Yes, madam.
So there is no need for an interim order.
Yes.
let the matter be listed after the return of the lien.
Let's hope that reconsider the matters the life of the backed by the court.
We are issuing notice, you'll have to be heard, because the division bench said appellate authority will pass orders without being influenced by the findings of the learned single judge.
Yes.
So that amounts to watering down the findings of the learned single judge.
Item number 5,
I cannot go to place to read. Oh, litigation, of course, बोलन होगा, नोट लगा नहीं। ऐसा ना नोट लगा ये वाला टाइप है। Yes, I think we disposed of a matter last week. Or was it? It was not disposed of. Do you have the number? WPC 4445. Sorry. 44.
of the 26.
Ah,
4463 of the 26.
okay.
And 4464 of the
4464. Okay, hard learned counsel for the petitioner is. The petition has been filed with the petitioner. We agreed by the recalling of the recommendation of the petition for promotion to a pump operator, which was earlier issued by the executive engineer, who issued the order for promotion,
proposal district level.
district level, divisional level selection committee. And which was subsequently recalled. So, being agreed, present writ petition has been filed. It is submitted that there are 3 other writ petitions which are pending before this court. This matter may be listed along with the state writ petitions and notice be issued in the matter. So, accordingly, Mr. R.R. Gogoi appears for respondents.
1, 2, 4, 5, 6, 7, and 8.
1, 2, 4, 5, 6, 7, and 8. Mr. D. Vora for 3. Let notice be issued, returnable 3 weeks. Since learned counsels for the respondents of appeal, certain notices are waived, however, extra properly furnished within 1 week. Let this matter be listed along with WPC 4445, 4463, 4464, all of 2023.
item number 6,
This matter pertains to completion and appointment. What had happened, my father died in hardness, was working as forester. Thereafter, I applied, initially I applied after 4 months. However, when I inquired about the method, they said the application was misplaced. Then they advised me to again give an application I gave. Then they did not communicate me regarding the DLC. Then I moved an application before the High Court, passed an order which wanted to find at page 33 to intimate me about the outcome of the petition. Thereafter, DLC at page 35 is the issue. My name to find
Your name is?
at page 36, serial number 2. The proposal of the following candidates could not be considered due to this
Serial number 2 is Sajid Chaudhary.
for page 36. Page 36.
36, looking at 36.
Sajid Chaudhary is just below that. Just below that.
Abhijit Kolita.
He already put it.
Date submission. Where is your first application?
Not an
Not if first application, not if they had lost it, if my complaint is up. I asked my client whether any acknowledgement or any signature was put.
When was the second application filed?
Second, 2018. It was.
Page 16.
When did your father expire?
2015, February.
And you submitted?
After 4 months, I submitted in the.
No, where is that? That 4 months application is not available.
Not available.
So
Then
there is
I-
no point making a statement unless it is supported.
Yes, that is true.
Ah.
But
So now we'll have to go by the subsequent application.
Yes,
So which is at page 16.
yes.
When was it submitted?
May, June 2018. In the. They also received receipt at page 14. They also acknowledged the receipt. With reference to page 14, I enclosing here with a photocopy of the application.
No, but they receiving doesn't give you any right because it has to be decided in terms, somebody has to receive it, you submitted, they received it.
But if first application I gave it to the Sandipur office, but no records are there. I asked my clients whether.
Is there any reference to show that your earlier application in some office communication that
But
you
I
had,
asked it, but
no, from the departmental documents, from these communications,
Yes.
is there any reference that you had submitted earlier?
Sorry, but no.
So 15, he died, you applied in 18, after 3 years.
Yes,
Yes,
I have annexed the judgment, but that is for just the reference. It says that it's just a procedure requirement. And it is a directory in nature, document which, copy, it's a reported judgment. Otherwise. There are many. The time period to submit application, or to see last paragraph. At page 39. Compassionate appointment by its very nature is based on.
but in this matter, the delay was by about 3 months.
Yes,
In your case, it is 3 years or more than 2 years.
yes, that is.
So you'll have to explain why the delay occurred, what happened. Will have to be looked into some. Because there has to be some cutoff date.
Yes,
Now, when will the delay be fatal? It may not be fatal for 3 months, 4 months, 6 months, depending on the facts of the case.
yes, yes.
If it is not fatal for 2 years, is it fatal for 3 years? Is it fatal for 4 years?
In particular, very bad.
Somebody will come after 10 years.
I don't have a good case. But it will be looking okay for the technical.
You get your instructions, Mr. Boy. Our learned counsel for the parties is, the petition is filed by the petitioner being aggrieved by the rejection of his application. Rejection of his prayer for appointment in compassion on compassionate ground. So petitioner's father, late father. So and so, late so and so. Was working as a forester grade 1 in the office of divisional forest officer. Who died in harness on 13/2/2015. He submitted that the late father of the petitioner was a regular employee, enjoying all benefits. It is submitted that pursuant to the death of his father, petitioner submitted an application before the DFO, Forest Resources Survey Division, Santipur, Guwahati. But although the case of the petitioner was placed before the DLC, no communication was furnished to the petitioner. Being aggrieved, petitioner approached his court by filing a writ petition being WPC 6061 of 2022. This writ petition was disposed of by order dated 21/11/2022, whereby the respondents were directed, whereby the district level committee was directed to communicate the outcome, the decision of its meeting held on 19/6/2018 to the petitioner within a period of 1 month from the date of receipt of the certified copy of the order. So, pursuant thereto, the minutes of the meeting, it was communicated to you. Minutes,
Yes, Lordship, after the RTI application, I filed an RTI application.
no, after directions of the court,
Before direction, Lordship, would see,
after direction,
yes. At page 34.
no, after the direction, you were not given.
Yes, Lordship, after that, direction was on 21/11/2022. It was furnished, 18. Maybe after the direction of. Page 34.
Pursuant thereto, the petitioner was communicated the minutes of the TLC meeting held on 19/6/2018. Wherein it is seen, wherein it was shown that the petitioners, along with 2 other persons, were not considered for appointment under compassionate scheme because of late submission of the application. So the petitioner is before this court challenging the said minutes dated 19/6/2018. So it is submitted that the petitioner earlier submitted the application immediately after the demise of his father, which was received in the office of the Forest Resources Survey Division, Santipur, which was not a copy thereof, however, is not available with the petitioner. Therefore, it is submitted by the petitioner that the rejection of the petitioner's case that was because of late submission cannot be accepted in view of the fact that the subsequent application, where is that page number? 16. Subsequent application, which was filed on
Undated, Lordship.
It is June 2015.
how do you know?
Lordship would see at page 40, it is received on 14/6/2018. Page 14. With reference to the I am enclosing here with a photocopy of an application dated, the application received on 14.
Receiving on 14th.
Which was stated to be received by the department on 14/6/2018. As is evident from the communication dated 2003/2023. Issued by the Office of the Division and Forest Officer. FRS Division, Santipur, Guwahati. Come on. Stop. The said application was filed by the petitioner as he was informed by the office, concerned office, that the earlier application filed by the petitioner was misplaced and he was asked to file a fresh application. It is in that context that the petitioner filed the subsequent application. Learned counsel for the petitioner has also referred to an order of this court dated so passed in WPC 4804 of 2016 to submit that the cutoff date is to be considered as directory and not mandatory while accepting the applications for consideration under the compassionate scheme for appointment. So, and in view of the submissions made, this court is of the view that the matter will require adjudication. Therefore, notice be issued Accordingly, notice be issued, returnable 4 weeks, Mr. R. Gogoi, learned comes studying council appears for the forest. Mr. Bora
2, 5, and 6.
I before one,
appears for respondent 2, 5, and 6.
I before one,
Mr. Gogoi for 1, 3, and 5. No, 1, 3, and 4.
okay.
Since letter councils have entered appearance, the responsible notices the waive. I will extra copies be furnished with to the respective council within a period of 1 week from today. The respondents are directed to obtain instructions and file their respective counters if so advised in the meantime. At least after 4 weeks.
Item number 7,
Yes,
The data collection could result from service. Also, report of the minor we get data of the minor in the year 2010.
what is a COFDO?
Minor is central organizer of village different organization. Initially, it was on honorary basis. From 2010, he was certified post. In the year 2015, without assigning any reasons, he was discharged from service. He approved this honorable post is directed to reinstate his service. Yeah, after my lord, after his reinstatement, he was reinstated in a completely different organization. So my lord, he has filed a petition for this honorable court, my lord. My lord has taken notice to that order, my lord, at page 15.
50.
50, my lord. 50 to relevant if the include what my lord, it is page 51, my lord. My lord, he has filed that petition is still pending before the honorable court that he was serving as your video since 2010. There is vacancy in the post and the services are also have been regular. In the meantime, he was transferred to different organization. This honorable court by order dated my lord 27/6/19 at page 51 directed that till the disposal of the writ petition, the petitioner service, even if appointed a home guard, shall not be disturbed without leave of this court. Then in the meantime, this writ petition was pending, my lord. My lord was awarded on last 2 months that my lord with regard to grade 3 again some of appointments were made. My lord, the post of the petition entry was expected to be made permanent was filled up, but those 2 persons have not joined, so there's to put the seal again. In the meantime, my lord, on 36/2023, again petitioner is discharged from service. My lord, I take your lordship, my lord, the order of discharge has not been handed to me. I find a representation for the authorities, my lord. I find a representation that is at annexation 16 page 64, my lord. On 19/7/2023.
No, the direction of the court was not for reinstatement, it was for
No, my lord,
disposal of the representation.
no, my lord, initially it was reinstatement, then I was reinstated to a different organization as home guard. So I find a petition, my lord, and that petition is at page 50, my lord. WPC.
That is still pending.
Pending. In that petition, the direction is that at page 51, till the disposal of the writ petition, the petitioner service, even if appointed a home guard, shall not be disturbed without leave of this court, because in this writ petition.
So he was not appointed as a home guard. After discharge,
My-
he was reinstated.
He was reinstated, not.
And the direction of the court is that he was reinstated as a home guard.
My-
Till disposal, he shall not be disturbed.
Yes, my lord. He has joined as home guard, and since 2018, he has been
Working.
working as home guard. My lord.
Then
And in the meantime, on 36/2023, he has been discharged from the.
how? If the writ petition is pending,
Yes, my lord. that is fine.
you have to file a contempt.
And my lord, with regard, my lord, that is my lord, the annexure 16 page 64, my lord. I waited from 36/2023. I went also for the order of discharge has not been even handed to me. I filed representation, I filed registered post, and the postal column is there, and that has been received by the office.
Mr. Sutia, what is this?
Mother, the initial appointment, there is no appointment. A backdoor appointment. Whether.
We are only concerned with the order of the court.
Yes, phone order is there, I don't know what they are, this appointment of our page 53. These are 24 May 2023 after selection by the state selection committee, these persons are appointed. as a CUVPO.
No, the question is, if there is an order of the board directing disposal, it shall not be disturbed, then this order remains, it has to be modified, vacated.
It is in 2019.
Yes. Is the writ petition pending or disposed of? Counsel for the petitioner submits it is pending. Interim order is also
Yes,
there.
so this disposal of the
Hmm.
Till to dispose of a reputation so that the event of the state is reversed, the control authorities may. No, I will obtain instruction regarding this for disposal or.
Is okay, heard learned counsel for the parties. This writ petition is filed by the petitioner who is aggrieved by, which is the order now, you are aggrieved?
My lord, at 36/2023, I have made amendment that paragraph.
That copy is not available.
That's not available. Paragraph
Is-
17, page 15,
Agreed by the order dated 36
2023.
3006/2023, whereby the petitioner was informed verbally that he was discharged from his services as homeguard, as a homeguard. Stop. It is submitted. The petitioner was not served with a copy of the same discharge order. In spite of applications being filed before the competent authority, copy of the order has not yet been printed. Stop. Learned counsel for the petitioner refers to the order dated 27/06/2019, passed in WPC 3774/2019, whereby this court, the coordinate bench of this court, directed that till disposal of the writ petition, petitioner's service, even if appointed a home guard, shall not be disturbed the leave of the court. Learned counsel for the petitioner submits that the writ petition is pending as well as, and the interim order and the order dated 27/6/2019 has also not been altered or modified. Under such circumstances, the respondent authorities would not have discharged the petitioner, and that too without serving any order of the petition. So, they agree with the present that petition has been filed. Whereas Mr. T.C. Sukia, learned additional government advocate, appears for the respondents. All respondents,
Yes.
all the respondents. Learned government advocate is directed to take instructions as to why the respondents have disobeyed the order dated 27/06/2019 passed in WBC so and so, and has issued termination order to the petitioner during the currency of the order dated 27/06/2019, and a copy of the same, a copy of the impugned termination order has also not been served on the petitioner. So,
The research already, present research order is not annexed. Earlier research order was.
copy has not been served, I will annex. The learned government advocate will obtain the required instructions and place it before the court within 2 weeks from today. Based on 21st of August. Extra copies of the writ petition be furnished to the learned government advocate within a period of 3 working days, when he will obtain the required instruction. 21st. Please, on 21st.
Not to this, my lord, thank you.
Supplementary list for motion item 50.
Yes,
Letters will be taken up after the activity.
not come,
We are trying to expedite, my lord, will come in some time.
right after some time, Mr.
But everyone matter is, I'll immediately come.
After some time.
Item number 51.
Yes, where is Mr. B Gogoi? Where is the Health Standing Council? Mr. Sutia, please inform your counterpart, Health Department. And please inform them that when the matters are called up, some council is required to be present. First of all, for the time, after some time.
Daily list for order stay visiting item number 9.
Are you for the Health Department? Who is for the Health Department?
My lord, Mr. Igoko appears for health department, he's on legs, my lord.
Somebody has to be there when the matter is called up. What is the point of apologies? You are disrupting in the flow of the work. There is a direction. Well, we are not concerned with his appearance, we are concerned with the directions of the court. He is supposed to furnish something.
My lord.
We are calling it after some time. If there is no counsel, no instructions, we are passing orders.
Item 9.
Item 9, I have filed the IF.
Negative.
Yes.
Negative.
For the number,
You have to issue notice.
I don't think it is what question by the.
Huh?
I have filed the IF.
Yes, so we'll have to issue notice.
My lord, that's good. My lord, when it's here, my lord. Instead of issuing notice, if it can be disposed of. Because my lord, what my lord, the petitioner has told my lord, the relief he got it, my lord.
Who is for the petitioner? Any objections?
The petitioner has been interviewed and promoted, my lord, not able to receive.
I think see the order, he wants to vacate last line. Last line. This is in the claim of the petitioner in chair. He has been superseded by the junior. Promotion of the restaurant number 5 to 7 was set to be cheaper. With the provision. Another 2019 method. No affidavit has been filed by my learned friend.
You are asking for vacating of which order? 29-3.
Yes, 29.
So what is the order here?
Order was my lord, the last part, first line at my line is near. My lord.
Will be subject to the result.
Yes,
Provisional.
provision.
Have you been promoted?
He have been.
I have been promoted.
He has been regularized
After them.
Promoted is
After them,
Uh,
if next promotion is also due, my lord, if their promotion is now considered, they will still a mark this time also.
My lord, I am not on.
Lordship may kindly see my read petition,
yes,
my prayer post,
yes.
my prayer post. My lord, a return the letter of members of the applicant, return the directions and directly the responsibility. Take look at which is the man, to the post of superintendent of food and civil supply consumer affairs, with effect of 7/3/19.
So now you are promoted.
I am promoted, my lord, but with
But
effect from.
7/3/19 effect is not given.
Not given.
All right.
That is the question. If the learned friend is caring for the government, is agree, then lordship to dispose of the matter.
Then second prayer,
Second prayer is withdrawn.
you don't require.
No,
If it is withdrawn,
Hmm.
I accept for a petition is that.
Yes, for who's for the respondents? Department. Department. So who's for the department?
I think.
Department,
Any
department.
activity.
Who's for the department? Yes. Ah. We will vacate this order and make it subject to the outcome of the writ petition. That will take care.
And my lord, on tenth, again, DPC is scheduled to be held.
Hmm.
If DPC is scheduled to be held, at this time also, they will still a march over.
It can be very well be challenged, my lord. I have no.
You challenge it subsequently,
My lord, it is a multiplicity of.
maybe, but as on date,
Again and again, I am will be declared.
He has been promoted, he has been regular.
you have been promoted.
I have been promoted on a.
Now,
My,
if
my.
if on the, if in the next meeting of the DPC, what will be, you are below them now,
Yes, I am below.
you are below them. So in the DPC also you cannot be considered. I mean, you will still be below them,
My lord,
then
then my candidature may not be accepted by the this time also. My promotion may not be considered. This time also, they will be promoted. They will again still a march over. People are landed then appearing.
now you are filing a vacating for what? Because your cases will not be considered.
My lord, I am not from that. My lord, he has been promoted. If he is promoted this time also, I have also no problem. My problem is that I have been promoted. My lord, they have been promoted much after than me now, and they have been regularized also. But my promotion is not yet regularized. That is the only problem. For disorder. For disorder, our problem.
If my promotion is regular.
My pay is regularized my promotion.
They have no problem.
If my lord.
I will give a
No,
direction.
your promotion being regularized with effect from the
93,
retrospective date.
my lord.
How
There
is-
will be no problem.
How is their regularization creating a problem for you? It can be altered if
If
ultimately,
they are regular, if their promotion is regularized now, they will still a march over.
maybe you challenge it.
My lord, again, what
But
is the
even
reason
otherwise,
why it is
even
now,
otherwise.
my lord?
Even otherwise, they are entitled to still a march as on date. Because they are, you have been promoted after them. As on date.
No, my lord.
That they have.
Here is a, Lordship may kindly see the rules, rule 13, my lord, in the requisition itself.
Yes,
Page 6, my lord, I have quoted the rules.
yes.
This is the rule 13 method of selection. The appointing authority shall refer to the committee the approximate number of vacancies likely to occur during the year in each category. Manage the committee to the charter of roles and personnel. Committee shall examine the character, roles, personnel of the candidate into consider the seniority and merit, seniority and merit of the candidate. And prepare a select list of the names of the orders of different separate. For the requirement of rule 6, 7, and 8, 9, 10. In every case, whereas junior member is cadre is selected in preference of this senior, in the cadre, the committee shall record in writing the reason of his occupancy. What is the reason for violation? It's a clear violation of the order. If it is rotated, allowed to perpetuate this illegality.
We are not allowing to perpetuate.
My lord, if.
We are saying that,
Again,
you are saying that this interim order is modified to the extent that their promotion, their seniority will be subject to the outcome of the writ petition. Where your writ petition is pending. Assuming your writ petition is allowed, then the seniority will be altered.
No, master, that will be on offer. If the DPC is not considered my case, my lord, this time also, because I am
The
junior.
TPC is not considered. If your writ petition is allowed, you'll get the benefits.
My
you'll
lord,
get the
in
benefits.
the meantime, I am in the second or third service.
When are you retiring?
After 2-3 years, my lord.
Hmm.
It is.
You're not
it is
retiring.
19, my lord, it is 19, now it is hearing, my lord, there is nothing.
We'll hear the matter, then let us hear the matter. You file your objection.
Alternatively, I have a suggestion, my
Yes.
let the government advocate obtain instruction from the.
No, you
government.
file your objections in the IA. We'll take up the IA. If you're
IA.
objecting to the IA, you file your objections.
Yes, I have objection because the.
All right, heard learned counsel to the parties. Issue notice returnable 2 weeks. Learned counsel so and so appears for the respondents. The respondents are respondent opposite parties are permitted to file their objection within 2 weeks. Since all the councils have represented the respondent opposite parties, no fresh notices need be issued. However, extra copies be furnished by the learned counsel for the applicant within the course of the week. No, within 3 working days. Let the objections be filed within 2 weeks, pursuant to which the matter will be listed for orders.
All right.
Can it be measured as a from early day?
2 weeks, they given 2 weeks. 28th August. 28th August. Okay.
Pending item number 51.
Yes,
Yesterday, the petitioner did not appear before the court, notice, he did not appear before the medical board notice. Also, it can be seen in page 3 notice, serial number 9, his name was there. Was absent notice. Page number 3. And lordship, the last page was the lordship earlier report lordship, which says that is 30% of the.
how do you calculate this percentage?
Report done by the experts.
No, so the problem here is there are 2 experts giving under the same department,
No,
giving 2 contradictory views.
but what I was telephonically informed was that it was done in 2017, and these are all lordship, this thing.
This gentleman has got problems with his vision.
Yes, lordship, it keeps on improving.
Improving.
In particular cases, lordship.
Where is that certificate?
Lordship, certificate is that.
Where is the certificate to say that from 40% he has now improved and therefore his disability is up to 30%?
Okay, there is no such certificate.
Then?
But lordship, the.
Who informed you telephonically?
Lordship, the principal.
We'll have to call the principal.
Lordship, but the report is there.
We need to have the views of the medical experts. There are 2 medical experts giving 2 contradictory views. And you are telephonically informed and you are passing this information to the court that his vision is improved.
Lordship, because the report says so.
Where is the report to say that his vision has improved from 40% to 30%?
Lordship, the last page, lordship,
Yes.
lordship, treatment, lordship,
Hmm.
it says impairment 30%, lordship.
It doesn't say that it has improved, it says 30%.
Yes, Lord.
Does it refer to the earlier 40% certificate?
No, lordship.
Then who will give that information?
Okay, in that case, lordship, I'll file an affidavit.
No, you don't file an affidavit. You call the physician who has examined him. Who has examined him?
Okay, there was a board, lordship.
You call the members, chairman of the board. Who is the chairman of the board? We are giving you opportunities after opportunities to get instructions, and what kind of instructions do you get when you cannot decipher in court yourself? You do not understand your client's instruction and you are placing it before the court.
It was done by experts, also. That's what I.
So therefore call the experts, since you don't know, who's the chairman of the committee?
I think it is the principal.
All right, call the principal. Medical college. List on Wednesday. List on Friday. In view of the earlier order dated so and so. 3/8/2023. Directions were issued to the Standing Council Health Department to produce the report in respect of the petitioner pursuant to the re-examination of the petitioner by the medical board, wherein it was found that the,
In the re-examination, he did not appear.
what re-examination?
Lordship, which was held on fourth lordship, he did not appear, lordship, page, the third page, lordship, which serial number is at 9, lordship. He was
And
absent.
what is this examination?
This was done earlier, lordship, in the first writ petition, lordship, which was disposed of, which was a part of the record, lordship, in the writ petition, lordship, at page 41, lordship. That there was reflection, lordship, to that. Page lordship 49, lordship. The earlier round of litigation, lordship, WTC 3324.
When was the examination, re-examination scheduled?
It was scheduled on, lordship, 4th.
Next one is on 27/7.
Until it did not appear on 4th.
On 17/7 was on another is ballot 27. Again,
On 17/7, he was asked to appear before the board on 4/8/2023, lordship, which he did not. appear.
On 4/8,
He did not. appear.
on 4/8, if he was required to appear, we would have indicated in the order, it was not informed. The order was passed on 3/8.
Lordship, it was there in the petition, lordship, it was stating, lordship, about that. On 17/7 notification, lordship, it was stating, lordship, and the lordship was directed, which, what is.
Have you gone through this order, 3/8?
Lordship, I have gone through, it was not reflected, lordship.
Have you gone through this order? 3/8.
Yes,
What is the purport of this order?
to give the report, lordship.
Which report?
The medical report, which he was supposed to appear or earlier appear, which is a part of.
Do you have a copy of this order? No. Go through this copy of this order and tell us the purport of this. Do you have a copy of this order? 3/8?
Right now, I don't.
You don't have. You know this copy.
51. Pursuant to the re-examination.
Yes, what?
It says that pursuant to the re-examination. But the re-examination was supposed to be held on.
You have still not read the order.
Will produce the medical report in respect of the petitioner pursuant to the re-examination of the petitioner by medical board, whereupon it was found that disability percentage of the petitioner is found to be at 30% and not 40%, as per certificate issued by earlier by Joint Director. Joint Director.
So how can, so what is the import of this order? You have to produce the medical report where he was found to be 30%.
Not sure that I have produced.
That is why we say, how from 40 it has become 30.
It was 16/6/2023 where he appeared.
Mr. Gugoi, your instructions are not clear at all.
Well, document they cover 2 minutes.
There is already some report.
Yes, my lord, one written.
Yes.
written report is there. It says 30%.
That is the whole problem.
Right.
This 30% is by a doctor, is a physician.
Yes.
And the 40% was also by a physician.
Right.
Now there has to be some finding that, yes, earlier 40%, now it has improved and he has become 30%. Who will give that finding? Assuming this is correct, that is wrong. We have to pass some order that the earlier 40% is incorrect.
No, my lord, that is not the my lord issue here. What you have to my lord kindly appreciate that.
Ah,
In this particular selection, there was a condition that whoever is otherwise selected on merit after participating in the selection in the PWD quota method, he will have to thereafter undergo a medical test again, my lord, before an expert body.
correct,
There is
we
a
agree,
verification,
but
they
we are
not
asking
comparing
you,
with the 40% and 30%.
we are asking you the import of a disability certificate.
Not so,
Who issues that certificate? The district authority.
my lord.
So the district authority on a date has issued a certificate to say that he is 40% disabled.
My-
That 40% is the benchmark under the act of the rules.
Yes.
He applies. You examine him and you say, no, it is not 40, it is 30.
Right.
On what basis?
But this is, my lord, it is a part of.
Either,
No, it is a part of
either-
the selection process.
no, either the physician has to say that it was wrongly issued to be 40, it is actually 30.
We are not, my lord, reviewing the certificate. Here the issue is, my lord. the
Then
contract-
then your selection process is contrary to the provisions of the statute.
And that in that case, my lord, he will have to challenge that, my lord.
He has not challenged it, we can direct you to obtain instructions and pass it.
Selection has been conducted by the secondary.
You cannot conduct an instruction contrary to a statute.
My lord.
You cannot conduct, it's a statute. You are expected to be aware of that. You cannot conduct a selection laying down a norm which is contrary to the statute and then say that it is not under challenge, therefore no orders can be passed. That can be done. We are asking you,
Thus, I am.
we are only we are
We are
asking,
not the authority who has conducted the selection.
no, correct, we are only asking you that give us a
Reasoning.
reasoning
Yeah.
as to the value of a certificate issued under the act. There is a certificate issued under the act
My lord.
by a district authority. It is not a case that the certificate was issued by an authority not prescribed under the act.
That part I understand. my lord.
Then- Now, if once a person gets a certificate showing that the person is certified to be a person with disability, and a particular percentage is there,
For it being direct, my lord, one thing I like to point out, my lord, by this particular report that is 30% for this particular selection, my lord. It doesn't mean that, my lord, this, that certificate, disability certificate will be cancelled. For this selection, there is a condition that you will have to bona fide.
you are repeating the same thing. You see, you are giving credence to the subsequent medical
The appointing
authority is giving the benefit,
Yes.
credence
My
to the subsequent medical examination, which means by effect,
lord.
you are overriding the earlier certificate by which he is being treated to be a person with disability to be 40%.
Right.
So the subsequent authority will have to give a reasoning. Subsequent authority will have to say
No,
that
my lord, here is one thing. We have done this, I am being for a helipad. We have conducted this entire, not only at the petitioner. Similarly, citizen persons are there, who appear, and accordingly, whatever result was found, it was given to the secondary department.
therefore we are saying that
There,
somebody will have to,
In this matter, Mr. Nayan Khatriyal is appearing, so these are next input from the side.
what can we do? What can we do? You are there, you appear,
I'm actually not appearing for the secondary, I'm for a different department.
you can be for anybody, then don't appear.
I know, I'm appearing on behalf. This finding. He's supposed to come in. Yes, he was on next.
This is education department.
yes, we have only conducted as per their request. We have conducted the exam. Special my lord, committee of board.
I understand everything, but this is conducted by a medical expert.
Yes,
One medical expert says 40%, another medical expert says 30%. How will the authority decide?
no, authority will rely upon the expert body. That's the criteria, one of the criteria. of-
Then what will happen to the certificate?
Certificate will remain, my lord.
What is the purpose? Then what is the purpose of the certificate?
Yeah, I cannot-
Prescribe with
They
this
have
case.
requested us, we have conducted the examination and we have found that it is certificate.
We wanted to know this 30% in what is the manner of calculation of this 30%?
That's part of course, I will detail this, my lord, I can say.
You have to find out what is the manner. If the medical experts are not giving us, we'll have to take the trouble of finding out how,
No, that.
whether it is possible. it is possible that it may not be 40%, it was originally 30%. We are just giving a hint.
Minor. By
Possible.
minor, by this time, he has improved. Right?
Then somebody has to certify that yes, he is improved. But it's very unlikely.
No, it has happened, man. In fact, in medical pilot also, well, there is a
Yeah.
specific criteria that we were well, get the kit under that, you will have to again appear before a medical. That's why they're being just certificate.
No, correct. That's why I'm saying.
It comes out. In fact, last
That is-
year, various,
That is why we want the report of the medical board. If the medical board certifies that yes, earlier it was medical board,
Lots of one thing, well, proper is this medical contract concern.
we don't know.
Yes, well, let me have pilot clarification.
So we, since the learned council was unable to explain, we thought the best thing would be
These
to.
are well, medical contract.
So you request the medical officers to come and assist you in court
My lord, fine.
if required. Otherwise, how do you,
I understand.
what credence do you give on the certificate? Then?
Cannot be ignored.
His very eligibility to apply is under question. Now, in view of the certificate,
Yes, subsequent development, yes, but he will not be a for that particular.
assuming he is not qualified for this on merit, let us say, same disability percentage, somebody else may have scored better marks. For subsequent interviews, this certificate will be used against him. That you are 30% there, would be.
Could be, of course. In the combination, well, some might, well,
The department may use it. Let us say subsequent interview, your records will reveal you 30%. You are not giving credence to the 40% certificate.
But in fact, well, for the second time, he was given an opportunity, not only him, well, others were complained against it. Again, a medical board was constituted, he was directed.
So we only want a medical report to say that,
Well,
It
it
was-
was designed medical card, well, I will explain to you.
correct, that it was,
We have the assistance from the authorities.
Yes,
It has been explained from their part.
bound to be. Nobody will just put a percentage like that. There must be a process, there is a process for calculation. So you tell us when you get it, when do you get
Well,
it?
the day after tomorrow,
Day after
tomorrow,
tomorrow,
this point,
Wednesday.
Wednesday. In the meantime, well, the education department also may place, well, under what condition, well, under what criteria they have kind of thought for this medical exam. That's why they have the certificate. It will have to be there in the drive or in the selection process.
That will ask them, but first we need to know if the medical examination reveals that he is improving and is not at 40%, then it goes to a,
To say that he is improving, well, that will be, well, possible only when the same doctors, well, they examine it after continuous.
not necessary, there are medical parameters. If he falls within this parameter, he will be graded as 20%, 30%, that
I will get you covered on Wednesday.
at the. But I hope you'll be available on Wednesday before the
No,
court.
well, I'm sorry for that. I will do that.
List again on Wednesday at the request of the Learned Study Council, enable him to obtain specific instructions in respect of the medical examination conducted by the medical board in respect of the petitioner, whereby he was shown to be a person with disability having impairment at 30%. So this instruction is sought for in view of the fact that the petitioner has relied upon a disability certificate issued by the health authorities, which is available at Annexure A to the writ petition, which shows that he has disability or low vision and is categorized as at 40%, and his disability is categorized at 40%. So this certificate, disability certificate, was issued by Joint Director Health Services, Amadi, as is required to be done under the provisions of the so-and-so Act. Persons with disability. it will be right of persons with disability act. And I read with the rules there on that. That apart, the petitioner has also been issued a unique disability ID, where also if disability is shown to be at 40%. Stop. The same unique disability ID card was also issued by the Office of the Joint Director of Health Services, Himachal. So let the matter be listed again on Wednesday 9th, enabling the London Standing Council Health Department to obtain the required instructions in the matter.
Daily list for admission item 10.
Yes, please, your lordship. Lordship, this is the long pending. The petitioner will be your lordship with the casual pressure working in the Sport India. Lordship, there is another department in the year. Lordship, at page number 32, lordship, there is a agreement between the respondent authorities and the petitioner, which was done before the Labour Commissioner capable, where they agree that they will look into the matter of regulation of my services. Till now, lordship, there is not complied with that.
Where is the agreement?
32, page 32, lordship. Yes, sir. Terms of settlement, lordship, point number 4.
Who is for the whole India? Who is supposed to take a decision in terms of the settlement?
Lordship, they have formed a committee, lordship, and they have given their reply also. Lordship, the last page, page 38. Regards to redressal self, lordship, they say that they are unable to organize. Page 38.
You are a casual worker,
Lordship, I am a
so your regularization cannot be done.
Services for 29 years, lordship. They are working since 1994. Lordship, at this stage, my commission is very deplorable, lordship. Monthly salary is 17,000. I have a quarter. Apart from that, there are no welfare schemes.
Are you given minimum wages?
Lordship.
Your salary is
Yes,
commensurate.
minimum wages, lordship. As per this particular settlement, it was increased to 333, lordship, per day.
What is the schedule of minimum wages?
Lordship.
What is the minimum wages that you are entitled?
Trying to lordship should be more than 500, lordship.
There is an affidavit in opposition where it says you are paid
Yes.
654.
600.
654 as wages.
Even in their affidavit, they are saying that they are providing me medical facilities, school facilities for children. Lordship, they went to say, lordship. I'm not getting this specific. I'm not getting this specific.
You have not.
Lordship. The school fees and everything, I am paying it from my own pocket. Medical also I am paying from my own pocket. Lordship. Even the basic welfare scheme, lordship, I think, I agree, lordship, they have provided me in the quarter. But apart from that, lordship, I couldn't get it.
I heard Mr. Swansman already counsel for the petition. Petition is filed with the petitioner, who is working as a casual worker.
Patient also.
driver under the respondent number 3. So he's under the respondent number 3, who's personal manager in the northeastern coalfields. I think his head office at Margarita. So petitioner was engaged as a casual worker as part of this 2209-1994 to drive the official vehicle of the manager. So the petitioner was removed from his casual service by the management on 25/5/1997 with a verbal note. So the petitioner agreed, approached the appropriate government, made a reference to the industrial tribunal, which was registered as reference case number 14C of 1999. The tribunal, the industrial tribunal, on conclusion of the proceedings, passed an award on 10/8/2000, holding the termination of the petitioner as a workman was illegal and it needs to be reinstated, re-engaged with immediate effect. And he was directed to be re-engaged as a workman in the same capacity where he was removed. The said order of the industrial tribunal was assailed by the management in before by filing a petition being WPC 5553 of 2001, challenging the award. Stop. The same was dismissed by judgment in order legal 6/2008, and which was confirmed in writ number 141 of 2008. Stop. The matter traveled to the FX board and the SLP preferred by the management, the SLPC number 18078 of 2008 was also dismissed. So, the review petition filed by the management, the review petition number 947 of 2008 was also dismissed by the apex court of 19/9/2008. Stop. Thereafter, the petitioner was directed to report for duty at Margarita headquarters, and subsequently he has been assigned to be a driver of the personal manager. So, the nuance of the petitioner is that although the petitioner has been excluded from other similarly situated drivers who were appointed initially casually basis have subsequently been regularized. And the same persons had all and joined their services well after the petitioner stopped. The case of the petitioner was taken up by the Assam Coal Mines Workers Union, and conciliation proceeding was initiated. Stopped. Upon conclusion of the proceedings, a memorandum of settlement was arrived at between the representatives of the Northeast Coalfields Workers Union and the petitioner. The representatives of the management of Workers Union and the petitioner. So, as per the settlement, the petitioner was required to be regularized immediately upon approval of the competent authority. So, however, in spite of such a settlement being arrived at, the petitioners have not been regularized. Agreed, the present petitioner has approached this court. The respondents have filed their counter affidavits resisting the claims made by the petitioner. So, the affidavit filed by the management, it is averred the petitioner has been paid an amount of ₹654 per day as wages. And the petitioner at this stage cannot be regularized. So it is further stated that it is further averred that the petitioner has been provided with other amenities like company water, medical OPD facilities for water supply, electricity, school facilities for children, etc. Notwithstanding that the petitioner is a casual worker. So the petitioner, the management contends that no drivers who were casual employees have been regularized in the Northeastern Coalfield till date, and therefore denies the statement of the petitioner that other drivers who were appointed to casual basis have been regularized, while overlooking the claim of the petitioner. Stop. The learned counsel for the petitioners, you have not filed a reply. Although did not file a reply, submits that the government's contentions of the respondents in their affidavit that the company water, medical facility, water supply, electricity, school facility, etc., stated to have been offered to the petitioner, stated to have been made available to the petitioner, is totally incorrect. Stopped as per instructions of the petitioner. He has not been furnished with any of these amenities. So, the pleadings, the petitioners does not wish to further file any further reply affidavit, and in that view, the matter. The pleadings in the writ petition stand completed. However, in the absence of, the learned counsel representing the Coal India is not available in court today. In that view of the matter, we can post it on Thursday if you want. Matter is posted again on Thursday, enabling the learned counsel for the respondents, the Coal India, who appear and urged before this court.
Thursday, I will be for production. 9.
Online not possible. The 22nd.
27.
The names of the councils for the Coal India should be reflected in the register, in the cause list by the registrar.
Okay.
Item number 11.
The request of Mr. K. Sharma, matter stand adjourned for 2 weeks. Weeks. Spencer appears for the respondents.
Item 13.
Yes. Hmm.
My lord, if someone the record to the concerned department, my lord, the additional advocate general is supposed to appear in the start of safe today. Not my big short day.
You're adjourning on the ground of the additional AG or on the ground that you have not received the records?
Digital AG.
You have received the records.
My lord, we have written the document, written the letter to the concerned department.
Have you received the records?
Not yet.
Learned counsel appearing for the respondent, Mr. Hendik, submits that the instructions have been sought for, but the same has not been received from whom? Finance? Which department?
PNRD, I'm representing the PNRD.
No, the instructions are sought for from the finance department.
Not in that the finance standing also would be the better.
Why don't you check up the last orders at least and before you make submissions before the court? It's a good practice. To go through the earlier orders, it's available in the web also. The earlier direction was to the finance department. Who's for the finance? All for finance. Mr. R. Puzari. Inform the finance, Mr. R. Puzari. We are keeping it on Friday. Mr. R. Puzari, learned counsel appearing for the finance, was supposed to produce the instructions. Is not available in court, matter stands adjourned until Friday. Mr. Hendik appears for PNRD department. Mr. Roman appears for the petitioner. Senior counsel assisted by Mr. Suvanji. It's on Friday.
Item number 14.
Please inform Mr. Finance Counsel.
After time limit, we are not yet to see any action.
What is your grievance?
In this matter, as now there is only a single point is subject to no injunction in the very. I can't put it.
You are a general category.
Application has been state by
What instructions are you looking for?
Your worship, there is the instruction for the labor department, since the advertisement was quoted for the labor department. That there was a reservation of only one post of driver that was for SC. Now we have sought instructions from the labor department. The labor department intimated us that they have transferred the records to the judicial department. So let me get the instruction of judicial department now. Your worship.
This is for which,
Item number 11.
no, driver in which department?
So the advertisement was called by the labor code, page number,
Labor code,
page number 11,
yes.
labor code 20.
Mr. You see, we recorded the name of the earlier government council, he is not here today. You do not know what transpired.
No, it's the letter is on record, your worship. We have written to them, but we have not received any instructions back from.
What instructions you require? You only to find out whether the cadre consists of one post or not, that's all. So who appears for the labor code?
Labor code 3 only appears. It comes under labor department. We have written to them on August 3rd.
Mr. D. Vora, learned government advocate submits that further time be granted to obtain required instructions from the labor from the respective department in respect of the allegations, contentions raised by the petitioner in respect of reservation of the post advertised. So, Mr. What is your name? PH Fukon, Warren. Learned Council submits that the petitioner is agreed by the fact that the advertisement in question is an advertisement for one post of a driver, which however has been reserved, and therefore the same is contrary to the provisions of law, as reservation is not permissible when there is only one post. And I'll let the matter be listed again on after 2 weeks, enabling the government council to obtain instructions.
Item number 15.
My report is denied, that's another court. My department of letter to the director.
At the request of learned counsel for the petitioner, matter stand adjourned for 1 week. 1 week.
1.
16. I'm being item number 50.
Yes,
My lord. Speaking order, my lord, it is page 51.
51.
51. Whereas in connection with the recruitment to the post of assistant engineer civil under water resources department, advertisement number so and so, dated so and so. Nidarsana Nilam, rule number so and so, API to the screening test as on 21/5/2023. Whereas as per the terms of the advertisement, the candidature of the state candidate was rejected on the ground of not submitting, uploading residency proof as well as the intimation letter to satisfy her claim of working as lecturer in Morigaon Polytechnic. Whereas the candidate by her application dated 17/7/2023 requested the commission to show her OMR sheet as well as the marks obtained by her and also revise the list of selected candidates before the interview process and release the cut-off marks for both the unreserved and reserved for women category. Whether the commission, while considering her petition, observed that she did not upload the required document, residency proof as per clause 5 of the relevant advertisement, and the intimation letter to prove her claim of working as lecturer in Monegaon Polytechnic. Further, she has submitted uploaded letter number so and so dated dispute 14 June 2022, issued by the Higher Education Department stating that the teaching and non-teaching staff of all categories of colleges will not require any NOC from concerned colleges, universities, polytechnic for applying for any other post in any government organization. However, any aspiring candidate may intimate to the respective college university authority for his or her applying for any post under any organization, including state, central government. The commission noted that in spite of the aforesaid instruction of the Higher Education Department of intimating the respective college university authority of her applying for the post, which cannot be ascertained whether he has intimated the authority concerned of applying for the state post in the commission, as she did not submit or upload the same while applying online application. In view of the above, her candidature was rejected for non-fulfillment of the required documents as stated above. Further, the commission is not in a position to entertain her request by her petition dated so and so till completion of the entire requisition process. Inform all concerned authorities. Now, my lord. Kindly come to page 36, there are 3.
What is the requirement?
My lord, my application was rejected on 2 grounds: for not submitting or uploading the residency proof and for not submitting the intimation letter to satisfy my claim of working as lecturer.
Where is that specified?
That's what my lord, regarding PRC, my lord, residency proof, it is specified in the advertisement clause 5, my lord.
Where is the advertisement?
My lord. Page 16. Clause 5, my lord, eligibility criteria.
Mhm.
The candidate must be a permanent resident of Assam. The candidate must produce TRC issued in Assam for educational purpose, employment exchange registration certificate, voter ID card of the candidate or his her parents will be treated as proof of residency along with the application form. So, my lord, residency certificate, my lord, as per eligibility criteria, it is a compulsory document which needs to be submitted, my lord. Now, my lord, my submission to this in this regard, my lord. Kindly come to page 53, my lord. My lord,
No, in this advertisement, is this the only condition? No other.
my lord, other conditions are also there, my lord.
Let us have a look at the conditions first.
Others all are satisfied, my lord, only this condition and one more, my lord.
No. Regarding this issue of uploading the certificates.
So, my lord, the other condition in this regard, my lord.
Yes.
My lord, may kindly come to page 21. Page 21, my lord.
21.
My lord, document certificate will be produced at the time of interview, my lord.
Hmm.
In this regard, there is another, my lord. Point H, my lord. H is 11.
H.
H,
Yes.
persons already in regular government service, whether it's permanent or temporary capacity, other than, my lord, this is important, other than casual, ad hoc, daily wages, hourly pay, contract basis, are however required to submit a declaration that they have informed in writing to their head office department that they have applied for the post, my lord. Now, my lord, who are in regular government service and permanent or temporary capacity, they need to submit, my lord. But ad hoc employees need not submit. Now, the petitioner, my lord, is an ad hoc employee under 3F, my lord. So my lord, I come to this also, my lord. So these are the conditions, my lord, in the advertisement. I could find my point number H, my lord, and eligibility criteria clause 5.
Yes,
My lord. Now, my lord, what happens, my lord? Kindly come to page 53. When here is a my lord option, my lord, where they ask page 54, I show my lord. Kindly come to page 53 for a moment. My lord, this form is not with regard to the instant advertisement, but this relates to the medical officer IMO ESI scheme appointment, my lord. Only for demonstration purpose, I have annexed this. I have also written in my application that this is only for demonstration. Kindly come to page 54, my lord.
yes,
The second option, my lord. Are you an employee of the state or government of Assam, my lord?
Mhm.
If we select yes, my lord, in page 54, we have selected yes. Then kindly come to page 55. When after we select yes, it comes, my lord, a small family norms is to be given, my lord, and no objection certificate from the employer.
Mm,
That option comes.
mm.
Now, my lord, kindly come to page 57. Again, if I fill up now page 58, my lord, what happens if I give no? Page 58, my lord.
Mm.
Second option, my lord, are you an employee of the state government of Assam? If I put no, my lord, then, my lord, the option comes, my lord, page 59. There, my lord, the middle portion. Valid employment exchange identity card issued in Assam, voters ID, PRC issued in Assam. So, my lord, since I am working as 3M, so, my lord, I have selected yes, and when I select yes, the option to upload PRC does not come. Now, in continuation of this submission, my lord, may I take your lordship to page 64?
Yes,
My lord, this is another advertisement with regard to the post of electrical inspector in the Inspectorate of Electricity under PWD. My lord, kindly come to page 65. Eligibility criteria. Point 7. And below that, there is an NB, my lord. The state government employees of Assam need not submit any document regarding domicile proof. However, they will have to submit no objection certificate from the respective employer. So, my lord, PRC is not required, my lord, for the government employee matter. And, my lord, regarding, my lord, in itself 14, 15. So, my lord, PRC, on the ground of PRC, my lord, this is my submission, and my lord, whatever PRC and all, my lord, I have annexed, my lord, in my additional affidavit, my lord, kindly come to page number 61, my lord. Page 61, my lord. This is my PRC, my lord, which I had with me.
Mm.
Then, my lord, page 63 is my voter ID card, my lord. Documents were there with me, my.
63,
See, voter ID card, my lord. Employment exchange certificate, my lord, page 62. All the required documents, my lord, was there with me, but only because I had selected yes against the option that are you a government employee. So they have asked me to upload the NOC, which as such I had uploaded only the NOC, my.
yes, then,
Then, my lord, the second ground of rejection, my lord, is that, my lord, I have not submitted the intimation letter to satisfy my claim of working as a lecturer in Moligaon Polytechnic, my. Now, what they are saying is that I have not submitted the intimation letter, my. My lord, they kindly come to page 73.
intimation or NOC,
Yes, yes, correct. NOC submitted, my.
NOC submitted.
Yes. NOC submitted, the intimation letter, page 73, I want to show, my lord. Page 73.
Yes,
My lord, this is the intimation letter which I already submitted on 19/12/2022. I applied on 22/12/2020. Intimation letter I already submitted. But since they have not asked to upload the same, so I have not uploaded. And my lord, page 70, kindly come to page 70 for a moment, annex 20, my lord. Page
Yes.
20. This is the application form which was uploaded, my lord. Kindly come to page, last page, my lord, page 72, the last page of the form, my lord, page 72. My
yes,
lord, second last declaration, my lord. No, my lord, last declaration, I have informed my head of office department in writing that I am applying for this post. Is there, my lord? And my lord, just now I have read the advertisement, my lord. My lord, I want to show one thing. Presently, I am working, my lord.
where is the rejection order?
My lord.
Where is the order passed by,
My lord.
passed by the APSC?
My lord.
Some order they have rejected your
51.
51. Where is your NOC?
My lord. NOC, my lord. My lord, page 52.
No, no, not 52. That is the circular. It is not the NOC.
My lord, this we have uploaded. Because our department does not give any NOC, my lord. This circular we have uploaded, my lord. We had no other option, my lord, other than this. They were asking for NOC, the word mentioned is NOC. Again said we have uploaded this document.
Or the intimation,
My lord.
or the intimation,
My lord,
letter intimation you did not upload.
my lord, there is option to upload only one document.
Let us come to the clauses again.
My lord. Process of the advertisement, my lord.
Yes.
Regarding
Advertisement is like 16, my lord.
Where have you submitted, where have you satisfied clause H? Page 21.
The person, page 21, my lord, clause 8 reads, my lord.
Hmm.
Person operating in regular government service, whether in permanent or temporary capacity. Other than ad hoc, my lord. I am excluded from clause 8, my lord. That I want to show, my lord, I have any documents regarding it.
But then you intimated,
I intimated, even though I intimated.
that you should have uploaded it instead of.
Now also, my lord, I can submit, my lord, the intimation letter is with me, my lord. If required, I can submit. Because, my lord, the advertisement nowhere says that the intimation letter has to be uploaded, my lord. There is no such clause, my lord, in the advertisement which says that the intimation letter has to be uploaded.
No, this clause H is a part of the advertisement.
My lord,
Clause H,
but this, my lord, has to be produced at the time of interview, my lord. That's what I am saying, my lord. Says 21, my lord.
at
Documents.
the time of
that-
interview.
So this produced at the time of interview, my lord, not after that, my lord. I
Yes.
produced at the time of interview. That is, my lord.
My probably is not, their candidate not understood the properly, my lord. PRC of the other or candidate is not equal if you are a government.
Hmm.
So that is, my lord, when you say that you are a government employee, there is a browser, then you have to upload NOC. He has uploaded in NOC place. That the circular of the government of Assam, and even in the government of Assam circular, my lord, you will kindly see what he has annexed, my lord, in the uploaded, my lord, the circular. In place of NOC, uploaded the, my lord, circular, and circular next part, my lord. Circular, my lord, one part he says, my lord, no NOC is required in government employee, but next part is there. However, any aspiring candidate may intimate the experience and the certificate of his field. So that is also not uploaded, my lord. Now say
So,
that it is,
uploading is as per which condition?
no, that is not in condition, my lord.
Then
Uploading is, my lord, if you, that is, my lord, reflected in the browser, my lord. If you say that I am a government employee, that is probably he has misunderstood that, my lord. If you are a government employee, then my lord, you cannot fill up the PRC portion, my lord. Then browser will come, then you have to upload that NOC. That he has annexed, my lord. He knows that you have to annex the NOC. In place of NOC, he has, my lord, submitted this circular, my lord. So that's why, my lord, we have not, we cannot ascertain that he is a government employee or not. Any document regarding that employment, even if the employment letter, during the letter of the letter of, my lord, no, letter of appointment also, my lord, do, my lord. But that was not done, my lord. So that's why, my lord, in case of other also, my lord, we have the same formula we have to apply, my lord. So now my submission before your lordship, my lord, yes. That is my learned man again submitted, yes, he said he has submitted NOC, but what
so
NOC?
first let us understand the advertisement, page 16,
My lord,
clause number 5.
my lord,
You must be a resident of Assam, permanent resident.
my lord,
Then you must produce the PRC for educational purposes. Upload relevant documents.
my lord.
Was it uploaded?
No, that's I'm saying. It is not required. If you are a government employee. It is not required if you are a government employee, then where as soon as you put that I am a government employee, then next browser will come, you have to upload. That is automatically, you have to upload NOC. Or that intimation letter. That two are not been annexed by him, perhaps, and instead of that, she knows it, my lord. She annexed that.
But your intimation letter is to be produced at the time of interview.
No, that is my, that clause is, my lord. That is in fact in the powers, my lord. Even in, my lord, government employee, this fact is not required. That is also not mentioned in the advertisement, my lord. There's who are government employee, they don't need to, but it is automatically in browser, it will be reflected, my lord. So, my lord, probably she has misunderstood that clause. Immediately, my lord, people came to know, she should have come to the office, my lord, file a application. Yes, these are the documents, my lord, we have to, but that is not been done.
But people can misunderstand filling up online applications. There is a possibility, not everyone is.
That's true, my lord,
As-
but we
as-
have to, my lord, that we have to. Same as thing we have to apply to all, my lord.
No, you apply to all, but it's not
No,
for
no,
the,
if you're
it's not for the,
No, no,
it's not for the
One
court
thing
to
I'm saying,
suggest, it's not for the court to suggest. But assuming if the browser requires that you are a government employee, and in order to support
yes, some
statement,
document, yes,
yes, to
submit.
proceed. Now, in view of that, you must specify what documents are there, and if these documents are not uploaded, perhaps,
No, that, she knows it very well because she uploaded the circular.
perhaps your browser ought not to have gone to the next page if these documents are not available.
No, that, your lordship kindly, in that place, what she uploaded, my lord, that government circular. But as for the government circular itself say, Then what are the documents to be used, my lord?
All right, we'll consider that. Now you allow her to appear in the interview.
I'll do it, my lord. Let them come with the application also to the chairman.
You file your
They'll do
application.
it, my lord.
What application is necessary? We are directing them
Regarding that, my lord,
regarding what?
regarding that, my lord, that you have not uploaded that NOC or anything.
It's
Because why I'm
open to them.
asking, there is a
It's
big
open to them to file.
My lord.
File.
So, my lord, now, my lord, your lordship kindly see, next step, my lord, when I have no objection, there will be, my lord, up to 11, my lord, there will be interview. Within 1 day, he up to 11, yes, he will be easily accommodated. But that is a mistake done there, but my lord, now, my lord, document which was not uploaded, that cannot be verified in my lord interview.
We are not saying that, you see, the whole purpose of screening procedure
My lord,
is to get the best,
exactly,
Isn't it?
that's why I'm submitting, my lord.
correct? So if there is a procedure for screening
My lord,
and some lapse here and there on
Screening
behalf of
already
the
done.
candidate, it is possible that notwithstanding that the candidate may be of a desired.
my lord,
Merit.
my lord, events, he is not.
Now, if you disallow a candidate to participate at least,
No, my lord, already screening part is done, now interview part, my lord, is there.
Hmm.
The time, what I am, why I am submitting result. I have no objection, my lord. I cannot concede, my lord, but I feel for that, my lord. Yes, we want, my lord, this government want best to them, my lord, best candidate.
so
my lord.
you
My
want them to now
No,
file a
that will be, my
representation.
lord, it will be a decision, my lord, that's why I am submitting, that he should, at least, my lord, in the meantime, that process will going on. Because otherwise, my lord, document which was he uploaded, other than that, not be
We
verified.
cannot direct them if they don't want to. We can give them liberty.
My lord,
But if they want to file, they don't want to file, it is their case because they are before this court trying to cull out an interpretation that these documents are not at all necessary in the first place. That is your case.
no, we have to follow the direction of the
No,
government, that's circular the
No,
government.
that's all right, that's all right.
No, that's why I am submitting, my lord.
So
And again, my lord, another question.
we
to the-
give them liberty to file that application without prejudice to their claim before the
My lord.
petition. That you can do
Otherwise, my lord,
if
document,
required.
otherwise, my lord, your lordship kindly see, admittedly, he is not, my lord, she is not an uploaded, my lord, NOC or nor a letter of intent. So now, my lord, if he is not uploaded, now it will not be verified, my lord. Document which was, my lord, uploaded, that will be verified in the interview, my lord.
You
That's why I am.
It can be
submitting, my
uploaded
lord.
now.
For her benefit, I am submitting.
You upload it, file an application, upload. We record that it is without prejudice to your claims here.
My lord, I think uploading will not be possible since.
No, not uploading, my lord, let them, my lord, like a letter to the, at least
And
authority.
then,
Then authority will, my lord, then it will be examined, my lord.
all right. You will find that without prejudice. We will record it is without prejudice to your claims made in the report. And you will permit her to appear in the interview.
That's, my lord, probably it is going on up to Friday.
So you permit. They'll do it today or
So that-
tomorrow.
Probably pending past them, my lord, my lord.
Yes, heard, learned, yes, anything else?
No, my lord.
Heard, learned counsel to the parties. This writ petition has been filed by the petitioner. Aggrieved by the fact that the petitioner was not permitted to appear in the interview. For the post of assistant engineer within bracket civil and the water resources department, which was advertised by the APSC by the advertisement number so and so dated 2nd December 2022. Page number 16. Learned counsel for the petitioner submits that the petitioner satisfies all the eligibility criteria and being desirous of applying for the same post had submitted her applications in the online mode as per the requirement of the advertisement. Stop. The application submitted by the petitioner was she was not given what? Admit card. What was she not given?
My lord, in the select list, and roll number was not there.
Select list.
So, my lord, I'll explain.
He appeared in a screening test, my lord.
Uh,
Those who are minor, fill up the form, all are allowed to minor sit in the exam.
written,
Written, that is a screening test only. So there is OMR based screening test. She appeared in the OMR based screening test, and thereafter we verified all. We verified all minor. Then while verifying, it found that minor, these are required documents are not aligned with the application. So that's why minor.
Her name was-
Her candidate has been rejected. So now. You
Yeah.
have already called for the interview, those who are cleared the
screening,
screening test.
Lordship query matter, page 28,
the
page 28.
petitioner appeared for the screening test. And having all the desired, having satisfied the eligibility criteria and having performed as per her satisfaction in the screening test, she was expecting her name to be reflected in the list of candidates who will be called for interview by the APSC. Stop. However, by notification dated 15th of July 2023, issued by the Controller of Examinations APSC, the roll number of the petitioner was not found among the roll numbers who were called for the interview. Stop. Thereafter, the petitioner approached the authorities and filed necessary applications. Stop. This application was disposed of. This page number 30. The representation was disposed of.
Yes,
This
by
was
speaking order, I can speaking order, my lord.
at page 51,
My lord.
filed in the additional affidavit.
Yes, my lord.
The representation dated so and so. Was disposed of by speaking order. Dated 20th of July 2023. Whereby the said representation was rejected for not within quotes for non-fulfillment of the required documents. And you strike it out and say the APSC rejected the representation of the petitioner on the ground that she did not fulfill the requirement of clause 5 and did not upload the relevant documents, namely either the NOC or the intimation letter as required. Stop. In that view of the matter, the representation was rejected. Stop. Learned counsel for the petitioner submits that in the meantime, the dates for interview have been notified. And the same are fixed by the APSC on 7th, 8th, 9th, 10th, and 11th of August. As per notification dated 19th July 2023. Having no alternative, the petitioner has approached this court. Right, one line before that. Learned counsel to the petitioner has also referred to this page 32 is about your rejection.
Page 30.
32.
No, that is, see this example she has given, what is your number, in a step of other man.
Okay.
You don't know, my lord, this I have just, I wanted to show that earlier also they made mistakes and they have given correction.
All right.
And even this time also, my lord,
It is submitted by the learned counsel for the petition and that there are instances earlier where if any corrections are required to be made, the APSC has permitted the same in respect of other candidates. Stop. Para Mr. P.J. Montal and a senior counsel assisted by Ms. So-and-so against for the APSC. Mr. Montal strenuously submits that the petitioner misunderstood the clauses in the advertisement. And as per the requirement of clause 5 in the advertisement, neither the NOC nor the intimation letter required was uploaded. What was uploaded was instead a circular of the government of Assam stating that NOCs are not required. What is that?
it is not clause 5, my lord. That is not clause 5. No.
Clause
No,
5,
no. What did she upload?
she upload only the circular of the government of Assam.
That's what I'm asking you. What does the circular specify?
Circular specified manner, NOC or NOC is not required if you
Give the intimation.
intimation.
Intimation is May, May. Is 15
May, if NOC is there,
May, my lord. We are submitting that this is an NOC only, ma'am. Page 52. This is an NOC, there's no NOC is required. They gave NOC, general NOC to all.
The learned counsel for the APSC submits that as per the requirements, the petitioner instead uploaded the circular dated 14 June 2022, wherein the commissioner, it's not a circular, it's a communication.
is a communication to all
Communication
department.
dated
All
14
the director.
June 2022 to the Director Higher Education and Technical Education, issued by the Commissioner and Secretary Government of Assam Higher Education, whereby it was stated that for teaching and non-teaching staffs in all categories of college, NOC will not be required for applying for any other post in government organization. However, aspiring candidate may intimate to the respective university for his applying for any post under any organization. Stop. The Learned Counsel for the APSC submits that in view of the fact that this requirement, the specific requirement of clause 5 in the advertisement was not fulfilled by the petitioner, she was not selected for the interview.
I can say,
Rejected.
I can say.
Her candidature is rejected. Stop. In rejoinder, if Mr. So-and-so Learned Counsel for the petitioner submits that the petitioner had already intimated to the college authorities about her joining in service, about her application for the said advertisement. And their perusal of the communication dated 14/6 believes that no NOC is required. And an intimation, if required, may be submitted by the aspiring candidate. Under such circumstances, the submission of the counsel for the APSC that our candidature was rejected because of her non-fulfillment of the eligibility criteria clause 5 cannot be accepted. That apart, Learned Counsel for the petitioner further submits that these documents are required to be produced at the time of interview, as is evident from clause H, which is enclosed to the advertisement, enclosed and is a part of the advertisement. Stop. The petitioner having satisfied all conditions and having intimated the college authorities, she may be permitted to appear in the interview and produce the relevant documents up to for the satisfaction of the APSC authorities. Correct. Learned counsels for the parties have been heard. Hearings on record available as on date is carefully perused. What is seen from clause 5 is that there are two criteria. Number one, candidate must be a resident, permanent resident of Assam. And number two, candidate must produce PRC issued in Assam for educational purposes. Stop. It is also seen from clause H that people already in regular government service, whether in permanent or temporary capacity, other than casual / ad hoc / daily wages / hourly pay / contract basis, are required to submit a declaration that they have informed in writing to their head of office / department that they have applied for post. Stop. These documents, along with other documents, are to be produced at the time of interview. Stop. The objection of the learned counsel for the petitioner, for the respondent, that in the absence of the necessary documents being produced by the aspiring candidate, no verification can take place, and therefore the same will never be examined, cannot be examined by the appropriate authority at the time of interview. Stop. During the course of the hearing, he has fairly submitted that since the process for interview is underway,
Right.
Up
Up to 11.
to 11th of August for one, the petitioner can still file an application before the competent authority requesting her, presenting her credentials / the necessary documents for due examination, so that she is permitted to appear in any of the interview dates, which is up to 11th of August. Stop. Upon due consideration of the submissions made by the counsels for the petitioner, this court is of the view that this matter will require some consideration. However, in the meantime, since the dates for interviews are till 11th of August, and the petitioner is prima facie satisfied with this court that she has the credentials and does satisfy the eligibility criteria in the advertisement dated so and so. For one. But perhaps for misinterpretation of the clauses, she had failed to upload the relevant documents. This court is of the view that as an interim direction, the petitioner will be permitted to appear in the interview, which is being held till 11th of August. And in order to facilitate that, the petitioner will file the necessary application with all relevant documents before the APSC authorities for
Intimation letter.
uh,
With the intimation.
whatever relevant documents,
I think they will present. No, there is no question. Already you are asked to see.
relevant, what documents are necessary? Only intimation,
Only intimation.
only intimation.
If no NOC, then intimation is enough.
So either NOC or the intimation letter before the competent authority. Stop. Competent authority will thereafter duly verify, and if found to be in order, will permit her to appear before the interview on 11th. No, why again do that? Upon such submission, the authority will permit her to appear before the
Yes.
interview on 11th.
My lord.
Stop.
On 11.
this application which is filed before the authority is in pursuance to a direction of this court, and therefore the same shall not prejudice the further claims of the petitioner raised in the writ petition. Stop. The interview to which the petitioner is permitted to appear,
Subject to
the results of the interview in respect of the petitioner will be made subject to the outcome of the writ petition. Let Spera, in view of the above order, let notice be issued, returnable 3 weeks, since Mr. Monto appears for the respondents. One, no, sorry, you're appearing for 3. 3, 4, 5.
3, 4, and 5.
Mr. Monto appears for 3, 4, and 5. As your name?
P. Sharma.
P. Sharma, assisting Mr. Monto accepts, appears for respondents 3, 4, and 5, therefore, and Mr. C. S. Hazarika appearing for respondent 1 and 2. Notices are waived, however, extra copies will be furnished within 3 working days from today. Petitioners, respondents are permitted to complete their instructions and file necessary affidavit in the meantime. List again. On 30 August. 30 August.
I'm grateful.
General list for admission item 16.
Yes. You can go now for somebody. Start typing. 1 minute. Mario Baba. You go and start typing because. Huh? Yes.
And you can be given as a three. And then first, you have had representation. And you can do representation. Last and then. He said that you will take him of SCR. I was not given that.
You are not given what?
When it everything free, had a. Yeah. Yes, we can see sometimes.
Yes.
On the top had everything, the so this is the. That's not considered for the. You need to take him of SCR, right, this direction. It was not defined. And they have actually said that it is not communicated to me. I defend that as it is not communicated to me, my lord, they cannot go on task, my lord, instead. As far as the report does, my lord, they can be communicated.
Yes, madam, for the respondent. ACR is downgrading, not communicated.
Our stand is that lordship, it is not actually downgrading. There is no adverse entry. Only his mark is not up to the benchmark. That is why he could not be promoted. But it's not an adverse entry. That is why it is
But
not.
downgrading. Was it not downgrading?
It's not downgrading. It's our benchmark is actually upgraded.
Huh?
Earlier it was.
Earlier it was.
He has to attain either 3 above average or high average, but for the 2016 and 17, he has exceed average 2 points.
Where have you stated that?
My affidavit and also the rejoinder to the reply note. Yes, Lord. From E from page 4, clause E of paragraph 4 not 4E, page 4. Clause
Page 4 of.
my activity. Then clause B is there, Lord. We have also given the cert in page 5.
So in 1819, 1718 was high average.
Last three years is required. So he has two averages.
No, 17, 18 is high average.
Yes, Lord.
So high average and average, high average is a higher benchmark.
Right. He has to attain at least two, three, average 2 points rating is well below the required benchmark above average. Above average or high average. Above average is 4 point or high average is 3 point.
No, we are reading your affidavit at page 4.
Yes, Lord.
There is a chart. Page 4.
Yes, Lord.
The chart says 16, 17 average,
Yes,
17, 18 high average,
high average.
18, 19
Yes.
average.
Average.
So
He is
between
supposed to,
now 17, 18 is high average, higher benchmark.
yes,
18, 19 again downgraded.
but in fact, Lordship, if there is a notification downgraded, Lordship not downgraded, for that he had received that above average, Lordship.
Where have you stated?
Our policy is, they are placed 37 and 38, Lordship, 38.
Okay, we'll take it up on some other day. It requires some amount of adjudication. We'll have it on.
And one case is also pending before the division bench where one point is also involved, is question Lordship regarding ACI.
We'll take it up on some other day. Huh? 14, all right, 14, this one 14. Second half, this bench is not available, there's a division bench. So if there are any other urgent matters, you let us know, otherwise.
Your Lordship, I can the 34, if your Lordship may take it up, all I just reply only to this.
34,
Yes, 34, I only just 2 minutes, and the item will give your Lordship one, even the item can get, this number today only.
May I please your lordship in item number 34, my senior Mr. S.K. is appropriate. Meta may be taken on the 11th of
It's your Lordship.
He-
11th of August, lordship.
your adversary is not available, counsel.
On 11th of.
Even though the council is not available, your Lordship is just.
All right, we'll have a look, 34,
Yes,
34 to
right.
50. Yes, then
19, I cannot 19. It takes on 5 days.
19,
190. The kind of takes on 5 days.
Friday. All right, Friday.
Item number 20, 21. And 22, same way. Similar level, some other level, any other.
Any other day you take it, any other day dates will be given.
Can be fixed date.
No, you get a fixed date, take it from the court master. I'm saying only if there are certain urgent matters, interim orders to be extended, etc. you let
Item
us know.
number 30. That is taken for 14 or
30, yes. 30,
No, no. I mean, I think 24.
yes.
It will be continue, Lordship.
Item 24, interim order, if any, will continue to the next date fixed. Based on 21st.
That is the lordship. Item number 20, lordship.
24.
Item number 20, I may be allowed to file additional affidavit, lordship.
File, why do you require permission? You can file it.
I may be allowed to file. additional-
You additional affidavit.
Yes, sir.
All right, item 28, additional affidavit permitted to be filed by the petitioner.
Allocation. Item number 17, my lord.
Hmm.
There's a application for
What is the urgency?
my lord, I will take it.
Document not any account time, not at any.
17,
2 weeks.
item 17, Gamudare,
No, no, $1.
$1.
Yes.
All
The
right.
applicable already filed in percent of the order dated my lord 29/5 my lord. I was asked to get some instruction. And the file applicable, what's the, can you fix it after another?
Item 17 after 2 weeks, give a date. Yes,
Item number 14 and 14.
for what?
Oh,
What do you want?
that was completely until.
Why, what is the urgency?
Was, we were asking for our. For big reviewing votes. They were.
What is the matter? What is the subject matter? Don't make a mention unless you are familiar with the subject matter. Do you have the brief? Next week. We'll go next week.
Item 31 and 33.
Item,
31 and 33. This is
yes.
the case for
Why?
I would assume this could take the day for next week.
Why 31, 32, 30 and 31?
No, your Honor, 31 and 33.
31 and 33, what are the matters?
It is complicated. Similar order has already been-
Occasional appointment, take it, you'll get it. Yes, you get it.
My lord, in item number 25 for respondent number 4, we have filed our affidavit in opposition
So,
because the date was fixed. We have filed.
very well, it will come on its own.
I am concerned about item number 30.
30, yes.
I think about the promotion. Taking is complete. Can it be taken on 14th?
We'll fix it on 29th August. 29th August.
Is it possible to?
Not possible, 29th. No. 29th. Right?
But that happened, but like, due to the tendency of 8%, the promotion of the additional order kept it.
Next week is difficult. We can give you an early date, 23rd, yes. Yes, yes.
Okay, in that matter, also notice needs to be issued. Respondent 7 to 28, which we newly included by the rates. That is why it's still listed for orders. Can it be listed?
Friday,
Public.
Friday. Yes, item number 48. What is the item? 34. 34,
30.
yes.
Here your lordship, the petitioner was removed from the service without holding any kind of inquiry. And that is as contemplated by Article 311 of the Constitution. And so far as the rule of Railway Rule 161 sub rule 2 is concerned, that was even violated. Your lordship may just come to the dismissal order at page.
We are, you said it is a 2-minute petition.
Only 2 minutes.
So we give you 2 minutes only, because it can be,
Absolutely fine.
yes.
Your lordship may just see the dismissal order at page 24.
No, if you want a decision on merits, then it can be in 2 minutes.
No, your lordship, in this dismissal order, there was 2 persons. One person has already been decided by this honorable court, and the judgment is there. And in that dismissal order only.
Ayush Tomar,
Ayush Tomar was already been decided. Here the petitioner is the Arun Sharma. That my case is only, it is the same at par with Ayush Tomar,
what do you say?
which is already been decided. While
Letter may be taken up.
while it is already been decided.
We don't know, it is for them to say, if they agree, we can dispose it of.
That is why the dismissal order is also quoted in the judgment as well.
Mr. Counsel. If the parties agree, then we can close it. When will you be back, Mr. You are appearing on behalf of Mr. Mehdi,
He will be available on 11th of August.
11th August. We'll have it on 11th then, Friday? All right, list on 11th. At the request of Mr. So-and-so. Who appears for the response on behalf of Mr. So-and-so. Counsel for petitioner is so-and-so. All right, 11th.
Yes, Amen. I think pertain noted. At the time, I should have been appeared for finance department in that case, because passed on order.
Item
Finance department.
Item?
13,
1-3.
yes.
Ah.
Hospital passed on order directing the finance department to place the record. In fact, Doctor, in this case, we have already received instruction on 29 July. And there it has been stated that finance department has nothing to do with this.
You don't know if you have passed, when is the matter fixed? It's on 11th. Will you remind us on 11th?
On 11.
You remind us,
For the record,
you show us, you point out the earlier order on 11th,
today's order.
today's order.
On
Not
last
today's order, you are referring to some earlier order.
On last date, Lordship, finance was asked to obtain instruction of it. Accordingly, we received instruction. Here it has been said that department has nothing to say about provincialization, regularization of ULC's employee and their pension money. Today, Lordship, I have got some reason not filed.
You pointed out on the next.
On the next date.
Next. All?
আরে ওপরে দিতে আছে তাই গম পাইছে মই এইটো লৈছো হা আইটেম 16 লৈকে হা এপিএসসি দে মই এগুলো নিয়ে নি মাই 34 21 দিছে No, 21 this one. 21 this one. 34 too.
No, I think 21.
21? মেনশন করো না আপনাদের করে তুমি মেনশন গুলো দিদি বহুত সনে কোন
So item 34. This one on the end of this. Second not
70 after 2 weeks
After 2 weeks. After 2 weeks, will you 30. Last one is to
Thank you.